According to a crime survey conducted by OnePoll, the average Brit commits one crime a day, often without knowing it. Most of these crimes relate to commonly misunderstood traffic offences, minor crimes committed so often drivers become oblivious to them. So, here are 5 traffic laws you don't know you're breaking. Number 1. Parking on the pavement. If you live in any of the 32 boroughs of London, then parking on the pavement could land you with a £100 fine. This is set out as Rule 244 of the Highway Code. You must not park partially or wholly on the pavement in London and should not do so elsewhere unless signs permit it. The difference between a must not and a should not is crucial, because refusing to abide by a must not under the Highway Code is a criminal offence, whereas refusing to abide by a should not isn't. So unless your local council has a traffic regulation order in force, then you can park on the pavement anywhere else in the country without breaking the law. There's just one catch. Parking on the pavement means driving onto the pavement, and driving on the pavement is a criminal offence under Section 72 of the Highway Act 1835, a law that predates motor vehicles itself. At the time, its introduction was to deter the then Victorian nuisance of horse, sheep, mule, swine, cattle, and even sledges being led onto the pavement. Parts of this act have never been repealed and are still in force today. The term carriages is extended in law to include motor vehicles. You can only drive onto the pavement as a means to gain lawful access to a property or tend to an emergency. Dismounting 2 wheels onto the curb as a means to park constitutes driving on the pavement. In which case, why aren't vehicle owners outside of London being prosecuted in droves? Maybe because driving on the pavement is only considered an issue when the vehicle blocks pedestrians to such an extent they have to walk onto the road to get past it. In which case, the driver is more likely to be charged with obstruction. Or it could just be that driving onto the pavement is so commonplace, the state doesn't have the resources to prosecute it. Number 2. Using your car horn. Car horns have existed as long as motoring itself. Under the Locomotive Act of 1865, a vehicle could not be driven on the road unless it was preceded by a man on foot waving a red flag and blowing a horn. But the necessity for speed superseded the man with the flag, and the horn found itself attached to the vehicle instead. And if the horn wasn't to your liking, then you could replace it with bells, whistles or chimes as the warning sound of your choice. The only reason the horn became the accepted standard was due to it being loud enough to be heard an eighth of a mile ahead. For some modern drivers, the purpose of a car horn is not as a warning, but rather as a means to vent frustration from inside to outside of their vehicles. But using a horn on a stationary vehicle in a built-up area is illegal and could cost you a £1,000 fine. Rule 112 of the Road Traffic Act states, the horn. Use only while your vehicle is moving and you need to warn other road users of your presence. Never sound your horn aggressively. You must not use your horn while stationary on the road or when driving in a built-up area between the hours of 11:30 p.m. and 7 a.m, except when another road user poses a danger. Motorists that repeatedly use their car horn as a mobile alarm clock to announce their arrival could also be prosecuted under noise abatement laws. If your sleep is being regularly broken by the wake-up call of a pre-7 a.m. car horn, then don't bother with the police. Instead, report it as noise nuisance to the local authority. Unlike the police, the council are obliged to investigate noise nuisance under the Environmental Protection Act. And if they don't take proper action, you could be awarded compensation by the local government ombudsman. Number 3. Passenger seatbelts. According to the Institute of Advanced Motorists, drivers' seatbelts reduce the potential for fatal injuries by 50%. So it's difficult to imagine that prior to 1965, seatbelts were considered luxury items in Britain and weren't fitted into vehicles as standard. The wearing of seatbelts only became compulsory in 1983. If you're caught not wearing one, you could be fined up to £500. But if you're driving a pre-65 classic car, or your vehicle was manufactured without a seatbelt, then you aren't obliged to have one fitted, nor will you be committing an offence by not wearing one. But you mustn't carry children under the age of 3 in the vehicle without restraints. There are other seatbelt exemptions aside from classic cars: licensed taxi drivers, driving test examiners, emergency vehicles, delivery drivers on short trips of no more than 50 metres, drivers with medical exemption certificates, and any driver who's using his vehicle to reverse. Oh, and who else is exempt from wearing a seatbelt? The royal family, but only when taking part in processions. The laws on driver seatbelts are common knowledge, but did you know that the rule applies to everyone in the vehicle, children and adults alike? The law states that wherever a seatbelt is fitted, it must be used, including back seats, coaches, minibuses and taxis. If anyone under the age of 14 is caught not strapped in, the driver can be fined, but from 14 over, it's the person not wearing the seatbelt who can receive the fine. Number 4. Using a handheld device while driving. In the last decade, over 200 people have been killed as a result of drivers using mobile devices on British roads. Yet, still the majority of drivers admit to having used a phone while in motion. This is partly due to the prevailing ignorance of when and where it's legal to use a mobile device in a vehicle. Figures compiled by the RAC show that 47% of drivers think it's okay to check social media or text messages while stopped in traffic. As a general rule, the only time it's safe to do so is when the vehicle is parked with the engine off. Turning the engine off makes all the difference, because it doesn't matter if the vehicle is stopped in traffic or parked at the side of the road. If the engine is running, then in the eyes of the law, you're driving. The only time you can legally use your phone while driving is to call the emergency services. Also, don't be taken in by thinking that a hands-free kit will protect you entirely from prosecution. Although making and receiving calls via hands-free devices is legal, you could still be prosecuted for careless or dangerous driving if you're paying more attention to your phone call than you are the road. But it's not just mobile phones that are considered handheld devices. Under road traffic laws, a handheld device is described as a device other than a two-way radio which performs an interactive communication function by transmitting and receiving data. This rather vague description is better interpreted as any electronic device that is used for sending text and voice messages, emails, images, or has internet access. Penalties for using handheld devices can be as high as a £200 fine and 6 penalty points, or even higher if you're a new driver, because under the Road Traffic New Drivers Act, you could lose your licence. This is because the threshold for totting up disqualification is considerably lower for the first 2 years you hold a full licence. To make it worse, the decision to revoke the licence isn't made by a court, but is done automatically by the DVLA as soon as you hit 6 points within the first 2 years. Number 5. Failure to disclose health conditions. In Britain, it's not just the courts who can take away your licence. The DVLA can withdraw it too if they think the driver is unsuitable to hold one, and that decision can be made without proof or prior notice. Negative reports of a driver's mental and physical health can come from a variety of sources, but the most common informants are the police and GPs, and they don't need your permission to disclose your personal data, and nor would it be a breach of data protection. So if you go to your doctor complaining about depression or anxiety, there's a strong possibility that he or she could notify the DVLA of your condition, which in turn could result in a notice that your licence has been withdrawn. When it comes to reports of ill health, DVLA shoot first and ask questions later, because for you to reobtain your licence, you'd have to satisfy them that your ailment doesn't interfere with your driving, which could mean resitting your driving test or taking a medical examination. Unfortunately, it's DVLA who set the terms of that reapplication and whether or not your licence will be reinstated. If refused, then your only avenue of appeal is through the Magistrates Court, who will weigh up the case for and against you holding a licence. It isn't a criminal trial, even though it's heard in criminal court, so you won't be found guilty or be given a criminal record if your appeal fails. DVLA have compiled a long, detailed list of the type of ailments that, if you're suffering from, you must disclose to them. Failure to do so could result in prosecution, especially if you're involved in an accident. It's estimated that around 3.4 million drivers have not disclosed notifiable medical conditions to the DVLA. Half of them presume that their condition doesn't affect their driving ability. The other half aren't even aware that they need to notify vehicle licensing. Your licence could be withdrawn if you suffer from ADD, bipolar, caesarean, eating disorders, Tourette's and déjà vu. Yes, even déjà vu. However, prosecutions for non-disclosure of medical conditions are extremely rare. Less than 100 drivers in England and Wales are convicted each year for failing to disclose, which is 0.002857142.9% of the 3.4 million drivers it is estimated should have notified the DVLA. Do you know of any other common offences, driving or otherwise, that people commit on a daily basis without knowing or perhaps without caring? Drop them in the comments below and they might make it to the next list.